Welcome back to the High Court Report. Today, we wrestle with National Republican Senatorial Committee versus Federal Election Commission, one of the most consequential campaign finance cases the court will hear this term. This joust over money, messaging, and muzzling involves a First Amendment fight over party coordination. Before we get started, I wanted to quickly remind people that there's only a few more days to send me your messages for our first ever High Court Report mailbag episode. I'm really excited about this episode. Send your questions and comments by Monday, November 24th. Email us at scotus.cases.pod@gmail.com or message us on LinkedIn at the High Court Report. I'll read your message on air and dive deep into the answers. What's your take on this term's biggest constitutional battles?
Please send in your submissions. Okay, let's tangle with NRSC versus FEC. This case may dramatically alter how political parties operate in federal elections. We're talking about a challenge to limits that control how much money party committees can spend in coordination with their candidates.
And here's what makes this case absolutely fascinating. The Federal Election Commission itself now agrees with the challengers. After President Trump took office, the FEC completely switched sides and joined the Republicans in arguing that these limits violate the First Amendment.
That's extraordinary. The agency tasked with enforcing campaign finance law now claims the very law they enforced violates the Constitution. So the court appointed an outside lawyer, Roman Martinez, to defend the law that nobody wants to defend.
The Democratic Party committees jumped in as interveners to provide the opposition that the case desperately needed. Without them, we'd have everyone agreeing on one side of what should definitely remain a contentious constitutional question.
Let's break down what this case really asks. The question presented reads, whether the First Amendment permits limits on the amount of money that the National Committee of a political party may contribute to political candidates in the form of coordinated expenditures.
Now let me read you the key statutory language that everyone's fighting about. This comes from Section 30,116D of Federal Campaign Finance Law. The National Committee of a political party may not make any expenditure in connection with the general election campaign of a candidate for federal office, which exceeds specific dollar amounts tied to the office and state population.
Wait, so you're telling me that when the Republican National Committee wants to help Senator Ted Cruz in Texas, they face stricter limits than a super PAC that wants to help the same candidate?
Exactly. That's the constitutional tension driving this whole case. Political parties, which the Supreme Court has called the backbone of democratic participation, face tighter speech restrictions than independent groups that have no formal relationship with candidates. And the magic word here that triggers these limits gets you into the constitutional weeds: coordination. If the RNC coordinates with Cruz's campaign on an ad buy, they hit these statutory caps. But if they operate completely independently, they can spend unlimited amounts.
The law basically forces parties to choose. Either coordinate with your own candidates and accept spending limits, or maintain your unlimited spending rights, but never talk to the people you're trying to help. That strikes me as a pretty unusual way to structure political speech rights.
Let's walk through how we got to the Supreme Court, because the procedural history tells an interesting story about how campaign finance law actually works in practice.
The National Republican Senatorial Committee and National Republican Congressional Committee filed this challenge back in 2022, along with then-Senator J.D. Vance and former Representative Steve Chabot. They wanted to spend more money in coordination with candidates, but the law's limits deterred them. The case went to the Southern District of Ohio first, which certified the constitutional question directly to the full Sixth Circuit Court of Appeals. That's a special procedure that federal campaign finance law provides for expedited review of constitutional challenges.
And here's where things get really interesting procedurally. The Sixth Circuit ruled 10-1 that a 2001 Supreme Court case called FEC versus Colorado Republican Federal Campaign Committee, known as Colorado 2, already resolved this exact question. The court said their hands were tied by that precedent. But Chief Judge Sutton, writing for that 10-judge majority, acknowledged that the Supreme Court's more recent First Amendment decisions create tension with Colorado II's reasoning. Several other judges wrote separate opinions basically saying, we think this precedent stinks, but we have to follow it.
Judge Thapar called Colorado 2 an outlier in our First Amendment jurisprudence generally. Judge Bush wrote that it conflicts with recent decisions. And Judge Riedler dissented outright, arguing that subsequent Supreme Court cases had already killed Colorado 2.
Then, the case reached the Supreme Court in December 2024, and that's when things got really wild. After President Trump took office, the Justice Department and FEC completely reversed their position. They filed briefs agreeing with the Republicans that these limits violate the First Amendment.
That created a bizarre situation where nobody defended the law that Congress enacted to prevent corruption in campaigns. The court granted certiorari in June 2025 and immediately appointed Roman Martinez to argue in support of the judgment below as court-appointed amicus.
The court also granted the Democratic National Committee's motion to intervene as respondents, so we end up with this unusual alignment: Republicans and the federal government on one side, Democrats and a court-appointed lawyer on the other.
Now, let's dive into the heart of these legal arguments because each side sees this case through a completely different constitutional lens. The Republican committees make three main arguments. First, they argue these limits severely burden core political speech and can't survive constitutional scrutiny under any standard. Their brief puts it pretty bluntly. These limits create a stifling effect on the ability of the party to do what it exists to do. They compare coordinated spending limits to prohibiting communication between a coach and quarterback late in a tied game.
That's a vivid metaphor, and their point gets to something fundamental about how political parties function. The whole purpose of a party, as opposed to just a debating society, gets you to elect candidates who will advance your platform coordination, seems essential to that mission.
The Republicans' second major argument tackles the 2001 Colorado 2 precedent head-on. They argue that subsequent Supreme Court cases have undermined its foundations and turned it into an outlier in First Amendment jurisprudence. They point to cases like Citizens United in 2010, McCutcheon in 2014, and FEC versus Cruz in 2022 as fundamentally changing how courts analyze campaign finance restrictions. These cases applied much tougher constitutional scrutiny than Colorado 2 did.
And here's their third key argument: these limits serve no legitimate anti-corruption purpose. The Republicans argue that Congress originally enacted these limits just to reduce what it considered excessive campaign spending, not to prevent actual corruption.
Wait, so you're saying Congress never claimed these limits would prevent bribery or quid pro quo corruption? That seems like a pretty fundamental problem for defending any campaign finance restriction. Exactly. And the Republicans make this point. How can a party bribe its own candidate? The whole function of political parties involves making sure their candidates will vote for the party platform once in office. That's not corruption, that's democracy working as designed.
Now let's flip to the other side. The Democratic Party committees, fighting as intervener respondents, make three completely different arguments defending these limits. Their first argument centers on stare decisis, the principle that courts should follow established precedent. They argue Colorado 2 correctly applied settled First Amendment doctrine and deserves respect under normal precedent rules.
The Democrats' brief emphasizes that for decades, the Supreme Court has treated coordinated expenditures as functionally equivalent to direct contributions, and everyone agrees that reasonable contribution limits pass constitutional muster.
Their key quote captures this: "The basis for Colorado 2 remains rock solid. None of the incremental developments in campaign finance law that petitioners emphasize undermine the twin pillars supporting Colorado 2. The Democrats' second major argument focuses on anti-circumvention concerns that they say have actually gotten worse since 2001. They worry about donors using parties as conduits to funnel unlimited money to specific candidates.
And here's where the Democrats get really concrete about modern campaign finance realities. After McCutcheon eliminated aggregate contribution limits, they argue that parties can now accept 6- or 7-figure checks from individual donors and transfer those funds to a single national party committee to spend in support of a single candidate.
So their nightmare scenario involves mega donors writing huge checks to joint fundraising committees, which then transfer that money to national party committees, which then spend it all on behalf of specific candidates through unlimited coordinated expenditures.
Precisely. And they argue this creates obvious potential for quid pro quo corruption. Wealthy donors could essentially buy access to candidates by routing contributions through party committees.
The Democrats' third argument warns about systemic destabilization of campaign finance law. They contend that overruling Colorado 2 would create a domino effect threatening other established precedents.
Their brief makes this striking point. If parties get unlimited coordinated spending rights, there will be no basis to prevent them from making unlimited contributions. 2. After all, the court has recognized for decades that they amount to the same thing.
And if parties can make unlimited contributions and coordinated expenditures, what's the constitutional basis for preventing other political groups from claiming the same rights? You could see the entire campaign finance regulatory framework unraveling.
Now let's look at the federal government's position. Because the United States brief supporting the Republicans offers some sophisticated constitutional arguments.
The Justice Department makes three main points. First, they argue Colorado 2 conflicts with the modern trajectory of First Amendment doctrine that has strengthened protection for political speech.
Their brief contends that post-Colorado 2 cases have repudiated its analysis of political parties' relationship with candidates, its definition of corruption, and its lenient standard of review.
Second, they argue these coordinated expenditure limits suffer from arbitrary and poorly tailored restrictions that don't actually target corruption. Here's a concrete example they provide. The statute exempts state committees' spending on get-out-the-vote efforts, but not national committees' spending on similar efforts. How does that distinction serve any anti-corruption purpose?
The government's third argument emphasizes changed factual circumstances since Colorado 2. They contend that donors now have abundant alternative channels for political spending, like super PACs. That didn't exist in 2001.
And they argue that technological improvements have made disclosure far more effective at deterring corruption than it was when Colorado 2 was decided.
Finally, let's examine the court-appointed amicus position, because Roman Martinez raises some really interesting jurisdictional challenges that nobody else addressed.
Martinez makes three main arguments. First, he argues this whole case should get dismissed because it lacks proper Article 3 jurisdiction. Since the FEC now agrees with the Republicans, there's no longer any realistic threat of enforcement.
Martinez's brief puts it plainly. The executive branch, including the Federal Election Commission, agrees with petitioners that Section 30,116(d) violates the Constitution. There no longer exists the actual and imminent threat of enforcement that Article 3 requires.
His second argument defends Colorado 2 on the merits, arguing it correctly applied the closely drawn test that Buckley versus Vallejo established for contribution limits. And here Martinez makes an important point about facial challenges. He argues the question isn't whether some coordinated party spending might involve genuine party speech, but whether all coordinated party spending must receive that treatment.
Right? Because coordinated expenditures can involve everything from developing party-specific advertising to simply paying a candidate's existing bills. Paying campaign expenses looks identical to handing the candidate cash.
Martinez's third argument warns about the destabilizing effects of overruling Colorado 2. He argues it wouldn't just affect this specific law, but would unsettle stable law by immediately calling into question multiple tenets of the long-standing campaign finance framework.
Looking ahead to oral arguments, what questions do you expect the justices will focus on?
I think we'll hear a lot about workability and line drawing. If parties get unlimited coordinated spending rights, but other groups don't, how do courts police that distinction? What makes parties constitutionally special?
The corruption analysis will definitely get attention. Do the justices buy the argument that parties can't corrupt their own candidates? Or do they worry about the circumvention scenarios that Democrats describe? The stare decisis analysis could prove crucial too. Several justices take precedent seriously, but others have shown willingness to overrule cases they view as wrongly decided First Amendment precedents.
And I'll listen for questions about broader implications. Do the justices seem concerned that ruling for Republicans could threaten the entire campaign finance system? Or do they think the current system already allows so much unlimited spending that these limits make little practical difference? The practical stakes here extend far beyond campaign finance law. This case could reshape how political parties function in federal elections and affect the competitive balance between parties and outside groups.
If the Republicans win, we could see party committees regain prominence in federal campaigns after decades of declining influence relative to super PACs and other independent expenditure groups.
But if the Democrats and court-appointed amicus prevail, it preserves the current regulatory framework and maintains important distinctions between different types of political actors.
What strikes me most about this case gets you to the fundamental tension in campaign finance law between enabling robust political speech and preventing corruption. Different people draw that balance in very different places.
This case also illustrates how shifts in presidential administrations can completely transform the government's litigation positions. The same law that the Obama and Biden administrations defended vigorously, the Trump administration now attacks as unconstitutional.
We'll definitely cover the oral arguments when they occur, and we'll track this case through to decision. Given the high stakes and strong disagreements among the parties, this could produce a landmark ruling that reshapes campaign finance law for years to come.
That's it for today's deep dive into National Republican Senatorial Committee versus Federal Election Commission. It perfectly exemplifies how seemingly technical legal questions can have profound implications for democratic participation and political competition. Thanks for listening to the High Court Report. If you enjoyed the content, please follow, rate, and share the podcast. Also, we always welcome fan engagement. So, follow our LinkedIn page or shoot us an email if you have any questions or comments. Talk to you soon. In our next episode, we'll highlight key moments from the October term. Thanks for listening to the High Court Report. If you enjoyed this analysis, please follow, rate, and share the podcast. You can also follow our LinkedIn page or send us an email with questions or comments. Talk to you soon.